Welcome to the video. Today we're uncovering why some heirs are being asked to sign non-disclosure agreements, or NDAs, before receiving an inheritance, including assets like 529 college savings plans. We'll discuss why this is unusual, what your rights are as a beneficiary, and the exact steps to take before signing anything. Let's begin. Here's our roadmap. First, we'll define NDAs in the inheritance context. Next, we'll examine why an NDA is typically a red flag. Then, we'll cover your legal rights to review core estate documents, such as the will and trust. After that, we'll walk through a step-by-step action plan. We'll also touch on 529 plan specifics, review some diagrams, take a short quiz, and end with key takeaways and next steps. NDAs associated with ordinary estate distributions are unusual. If an executor or attorney is insisting on secrecy before releasing your inheritance, that indicates atypical circumstances. It could involve a conditional gift or a structure designed to limit transparency. Importantly, beneficiaries have a right to review foundational documents, including the will or trust instrument. If the fiduciary refuses to provide those, it may be a breach of duty. We will explore what to do next. Let's examine the red flags. NDAs are not standard for routine distributions. When secrecy is demanded, it frequently advantages the executor or trustee rather than the beneficiary. This might hide conditions in a trust, sensitive assets, or other provisions. Critically, an NDA can limit your future legal options or leverage. If a fiduciary is using an NDA to avoid disclosure or an accounting, that is particularly concerning. These are signals to slow down and seek independent counsel. This flowchart shows the decision pathway when an executor requests an NDA. The process begins with the request and immediately branches to requesting the full will or trust and consulting independent counsel. If documents are provided, the next step is legal review. If they are not, the path leads to escalating with a court petition or a regulatory complaint. Only after a complete review and legal advice should you proceed. The key message is not to sign prematurely. Here is your action plan. First, pause and do not sign anything under pressure. Second, request the full will or trust instrument in writing. Third, ask for inventories, accountings, and distribution schedules. Fourth, retain independent counsel experienced in probate or estate litigation. Fifth, document every interaction and follow up in writing. Sixth, if the fiduciary refuses documentation, consider a formal demand or a court petition. Seventh, after counsel reviews everything, assess whether an NDA is necessary. Finally, only proceed if your attorney confirms that the terms protect your rights. On the left is a typical distribution. There is open communication, and the will or trust and accounting are available upon request. There is no secrecy requirement for receiving funds, and beneficiary rights are honored. On the right, an NDA demand introduces secrecy. Documents may be withheld unless the NDA is signed. This can limit transparency and restrict legal recourse. It is often a signal of unusual or complex arrangements that merit careful scrutiny and legal guidance. This table summarizes roles and duties. Executors and trustees have fiduciary duties to act in beneficiaries' best interests and according to governing documents and law. You can ask for the will or trust, inventories, and accountings. Red flags include refusal to provide documents, pressure to sign NDAs, and unexplained delays. Estate attorneys typically represent the fiduciary, not you, unless you engage one. As a beneficiary, you have the right to information and to enforce duties, including petitioning the court if needed. Before we continue, a quick but important disclaimer. This video is for educational purposes only and is not legal advice. Laws vary by jurisdiction. You should consult a licensed attorney in your location. Watching this video does not create an attorney-client relationship. Do not sign any agreement, including an NDA tied to an inheritance, without seeking independent legal counsel. Quiz time. The question is, are NDAs typically required for standard estate distributions? Option A, yes, always standard practice. Option B, no, it's unusual and a red flag. Option C, only for 529 plans. Option D, only if the executor asks nicely. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is no. It's unusual and a red flag. Standard estate distributions rarely require NDAs. If secrecy is demanded, slow down, request documentation, and consult independent counsel before signing anything. This sequence diagram maps the interactions. The executor or trustee first requests an NDA. The beneficiary asks for the will, trust, and accounting. The fiduciary's attorney might refuse or delay, prompting the beneficiary to retain an independent attorney. That attorney demands the documents. If refusal continues, a petition to the court is filed. The court may order disclosure or set a hearing. The resolution leads to documents being provided and reviewed, or the court compelling compliance. Next, focus on documentation. Request the complete will or the applicable trust instrument. Ask for inventories, accountings, and a distribution schedule. Require a written explanation for any conditions or delays. Set reasonable deadlines and follow up in writing so there is a record. If the fiduciary refuses, consider petitioning the court for information or relief. Do not move forward without understanding exactly what governs your inheritance. Let's address 529 plans. Distribution should be straightforward, according to the plan rules and governing estate documents. An NDA tied to a 529 payout is especially unusual. Confirm who has legal control of the account, such as the owner, successor owner, or trustee. Verify the designated beneficiary and permitted uses of funds. Do not accept secrecy in place of proper documentation or transparency. Second quiz question. Which documents do beneficiaries have a right to review before agreeing to distribution terms? Option A. Only a summary letter from the executor. Option B. The full will and/or relevant trust instrument. Option C. Nothing until after signing an NDA. Option D. Only 529 plan statements. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is the full will and/or relevant trust instrument. Beneficiaries generally have the right to review the governing documents. If a fiduciary refuses to provide them, that may violate their duties. Seek independent counsel and consider court remedies if necessary. This timeline contrasts a typical estate process with an NDA detour. The standard path includes probate opening, notices to beneficiaries, inventory and accounting, and distribution. The detour path introduces an NDA request, the beneficiary's document request, counsel review, and possibly a court petition before distribution. The diagram illustrates how an NDA demand can create delays and extra steps, reinforcing why you should verify its necessity and protect your rights. Let's recap the key points. First, NDAs tied to standard distributions are unusual and should be treated as a red flag. Second, beneficiaries have the right to see the will or trust before agreeing to terms. Third, never sign under pressure and consult independent counsel before proceeding. Fourth, secrecy often benefits the executor rather than the beneficiary. Finally, document all requests, set reasonable deadlines, and escalate through the courts if necessary. In summary, confirm your rights by demanding the full will or trust. Request inventories and accountings. Always seek independent legal advice before signing any agreement. If your requests are refused, consider petitioning the court or filing appropriate complaints. Proceed only after you fully understand the implications and have been advised by your attorney. Thanks for watching. If this video helped you, please like, share, and subscribe for more content on protecting your rights in estate matters. Share your experiences or questions in the comments so others can learn from them as well. See you in the next video.